Good afternoon. You've logged in as Moto G Stylist. Are you Michelle Long? All right, I ask you to unmute your microphone if you would.
There, is it unmuted?
Yeah, I can hear you now. Thank you. Welcome, everybody. It's 3 o'clock. Time for our small claims docket. Several matters set for this afternoon. One where it appears we have both parties plus their dog, and one where we don't have each party, and one that wasn't really set. But Mr. Neal, why don't you come up to the podium? This is file number 252219SC. It's a small claims case, or at least it started as one. The original title of the case is Savannah Salmon versus Ron Neal. We had a hearing on November 17th, and the defendant was here on November 17th, as was the plaintiff. In the meantime, his insurance company, Mr. Neal's insurance company, has filed an order removing the matter to the general division of the court. That was filed on January 9th. So the matter's been removed by your attorney, who is on behalf of the insurance company. They filed an appearance on your behalf.
Really?
Kelly M. Mann, Quateros, Prieto, Wood, and Boyer, PA, from Novi. They filed a motion to remove the matter to the general division of the court, and then they promptly didn't file an answer. So that you're subject to default for $3,000. So I'm going to set this matter for entry of default. I would suggest you call them and ask what's going on. I'm going to have the court officer take you out, give you a copy of that, but they did file an appearance listed as your lawyer, remove the matter to the general division of the court where small claims rule don't apply, but the real rules apply. And they're supposed to file an answer. It says right here within 14 days, which would have expired January 25th.
I wasn't aware of all that.
Probably not. So we'll give you that. You call them and say, hey, what's going on? I'm about to get defaulted for $3,000. We'll set it for hearing regarding the entry of that default and see what happens. All right, I expect somebody will wake up and file something. But you go and get a copy of that so you know what they did.
Go with him?
Yes. All right, we had another matter, which was Grasshopper versus Port of Call. This is a mowing contract for a business that didn't pay their mowing bill. A judgment entered. They've been trying to serve the defendant to do discovery for collection, but they've been unable to do that. So no service. Will continue the matter at least 30 additional days. Next, we have Alexandra Gross Mavrelis versus Robert Vaughn Jr. This is a claim for $7,000. The file number is 252278. Let's make sure Mr. Vaughn isn't here. Hello, Deputy Myers. I'm looking for a Robert Vaughn Jr. for small claims. All right, thank you. Bye. I call every time, except once, didn't call. Then the person was out there. So it doesn't take but 2 seconds to call. Mr. Mavrelis, would you state your name, please?
Yes, Alexandros Mavrelis.
Would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, Your Honor.
This is a claim for $7,000 for failed construction projects. Mr. Mavrelis contends that much more than $7,000 was actually owed, but he limited to the small claims amount of $7,000. Mr. Vaughn was personally served with this. and has failed to appear. He was personally served on December 1st and again on December 15th. I continued the matter for 30 days. Oh, I guess there was a question about the certified mailing. Couldn't tell who signed it. Well, he certainly knows about it now because he was personally served on the 13th. Mr. Mavrelis, did you contend that at least $7,000 was owed by this defendant to you as a result of several construction projects you hired him to help you with in the state of Michigan?
Yes.
All right. He isn't here to defend it, so he loses by default. I find that he owes you $7,000. Getting the money is the easy part. I mean, getting the judgment is the easy part. Getting the money is a little more difficult. So I find damages in the amount of $7,000. Court costs the amount of $86.25 and the extensive service costs of $201.54 for a total of $7,287.79. Now, the next step in this process is what's called a discovery subpoena. That's what Mr. Grasshopper was trying to do with the guy that wouldn't pay his mowing bill. He has 21 days to pay this, or he's subject to collection. After that time, you can pursue what's called a discovery subpoena. The clerks can help you with that. They will serve him once again, and it compels him to come here to the courthouse. And then he's placed under oath, and he can come by Zoom. I guess this will be in person. You can appear by Zoom. He is placed under oath. You're allowed to ask questions like, what's your social security number? Where do you have your bank accounts? What vehicles are registered to you? Other things to do and attempt to collect. If he does not appear pursuant to the subpoena, he's in contempt, could actually be subject to a bench warrant with a cash bond. So you can only ignore this for so long. You don't have to come to the hearing, but if you don't, you automatically lose. That's what happened.
Your Honor, you mentioned what the person filed or tried to file before. What was the name of it again? I missed it.
A discovery subpoena.
Thank you.
After 21 days, you can contact the clerk. I was reluctant to do the default last time because I wasn't sure we had proper service on the defendant. We do now.
Yeah.
So he was given the subpoena personally, the court summons personally by a court officer. So he doesn't have to come, but then he loses. He's subject to collection, like garnishment of wages, seizure of assets, seizure of property, but he has 21 days to pay. Now, the truth be probably known, he owes much more than $7,000, but this would resolve all the existing claims. And so, as I said, the easy part's getting the judgment. If more than 21 days pass and you haven't seen any money, contact the clerks and they will help you with the discovery subpoena process. All right, anything further?
None for me. Thank you.
All right, thank you. Hopefully he'll pay, but I would be surprised if he did, so I expect we'll be having more hearings in this regard.
Until then, thank you.
All right, thank you. He's in California. I shared with him how our weather was in Michigan, and didn't seem to miss being here. All right, next up is Adventure Credit Union versus Michelle Long. I've got Jen R. from Adventure Credit Union. What's your name? From Adventure?
Jennifer Roy, R-O-Y.
What's your position with Adventure?
Financial restoration.
And are you Michelle Long?
Yes, sir.
All right, well, everyone, both of you, please raise your right hand. You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, sir.
Let me explain, Ms. Long and Ms. Roy. Just a minute, let me check this off. You're here in small claims court. My name is Judge Middleton, and I'm the judge that does 99% of the small claims matters. In small claims, the matter is limited to a claim of $7,000. The last gentleman sued for $7,000. Neither party is allowed to have an attorney in small claims court. There is no formal record being made in small claims court because there is no appeal. Any ruling or decision made here in small claims court is final. Either party has the right to remove the matter from small claims to the general division of the court. But if you do that, you have to tell me before we start. That happened in at least one case today. But once we begin here, any decision is final. You understand, Ms. Roy?
Yes, Your Honor.
And Ms. Long?
Yes, Your Honor.
All right, everybody ready to proceed?
Yes.
All right, this is a claim for $3,887.85 plus costs for a loan that Adventure Credit Union made to Michelle Long on a vehicle that was repossessed. This is a shortcoming, I believe, after the vehicle was repossessed and sold. Ms. Long, what's your position?
Well, at the time when it was repoed, I went in with the money to get it out, and get it paid for. But I didn't have 500. I was minus 500, and I asked and pleaded with Adventure beforehand. I just got a job at American Axle, and I was waiting on my next paycheck, which was 2 days, to come in, and I could get it all caught up. They refused to help or assist in any way, so I had to leave the car.
Well, Ms. Vaughn, Ms. Roy, what can you tell me about this?
So it looks like we did receive that call from her regarding wanting to pay a partial amount, or wanted to, from the notes that we do have, is stating that she wanted to do a payment arrangement, did not specify specifically any date that she would have additional funds, but did state that, that she only had so much amount of funds. We did specify that it was our manager's decision of what she needed to pay in the certified funds, along with the repo cost to the repo company, in order to reinstate the vehicle and get the vehicle back. After that, we did not hear from her. That was on 11/10/2023. And then on the 22nd, our repo company, which is M&W, they emailed us asking if we could file the claim regarding this and move forward with it. So we hadn't heard back from her since then. So, we don't generally just say, no, we're not going to take. Can I finish, please? We don't generally.
Just a moment. Ms. Long, we're in court. We're not sitting around the kitchen table. So she'll finish what she has to say, and I'll give you a chance for what you have to say. Ms. Roy, I don't know anything. Yeah. There isn't a copy of the loan. I don't know what kind of car this was. You simply filed some bare bone pleadings that said this money is
documentation.
Let me see if I'm missing something. No, it's not much here. So how did you come up with this figure for $3,887.85?
That was what was left to pay on the vehicle after we did all gap claims, and any type of insurance that we could get.
All right. Well, it's one thing to say it in a lump, but what's the calculation? I don't know what kind of car it was. I don't know how much the loan was. I don't know what the interest rate was. I don't know when it was repossessed. I don't know how much the car was sold at, which in general civil, we generally have that stuff. But this
It
is
was
small
repoed
claims.
over 2 years ago.
Yes. Probably a pleasant surprise when you got this lawsuit in the mail.
Yeah.
Statute of limitations is 6 years. They say $3,887.85 is due, but I don't know how they came up with that number. Do you agree with that number or disagree?
No, I disagree because I told them at the time when I came into the office there and I talked to them, I told them that if I can't get it out today, to do what you had to do to get rid of it because I couldn't come back. I don't even have the job at Axel anymore. I'm living in a motel room. Okay, I can't find a place to live right now because I have an eviction on my record. So nobody will rent to me. I work at Walmart and I just got a full-time position. Yesterday, I started my first 8-hour shift.
Good for you. All right. So anyway, I'm buying a pig in a poke. I don't know. What kind of car was it?
It was a 2011 Malibu. It had maybe 85,000 miles on it. Maybe a little more.
How much was the loan for?
The original balance was for $13,690.94.
All right. So the loan was for $13,690. Ms. Roy, you probably didn't start this loan. Somebody probably handed this to you and said, sue this lady in small claims court. Well, you need more than this. By the way, she owes us money. So, all right, the loan was for $13,680. What was the balance due at the time it was repossessed?
Let me take a look at that.
I would have had it paid off by now if they would have let me take it.
Yes.
At the time that it was repossessed, it looks like minus the proceeds there. So let's see. This was 2023 was the last check or payment that we received. $10,691.41.
What was the date of that?
That was on 8/25/2023.
All right. And then it was repossessed?
Yes, and it was sold at M&W auction proceeds, and we did receive $5,809.75 for that. And then we also received funds for a gap claim for $1357.58. So that's when we got down to that amount as well.
I've said this before. These are my perhaps least favorite kinds of cases.
I can imagine.
Aftermarket auto loans, the cars are sold. Was this part of a car dealership or was this a separate loan company?
Correct. It was a dealership. We only provided the loan to the member.
Who is the dealership?
I don't know.
Who did you buy the car from this long?
I went to the dealership in I think it was
Charlotte.
Lansing or Charlotte.
Mhm. Yep. It was a Team 1 Chevy Buick GMC.
All right. And Adventure was simply the loan company.
Yes, sir.
These are better than where they're selling cars at a prior price because people are credit challenged. They have interest at extremely high rates. They're repossessed. The cars are then sold at auction for $5,800. Then they wash it and then sell it for $10,000. In the meantime, she's on the hook for the rest. It appears, as a record was supplemented, that on August of 2023, the shortcoming on the vehicle was $10,691.31. When you told them, do what you got to do to get rid of it, I guess you gave them the authority to sell this. They sold it at auction for $5,809.75 plus some gap coverage. So let's add that up. 5809.75 plus 1357.58 is $7,167.33. So if we subtract 10,691 minus 7,167.33, we get 3,523.98.
There's also interest in there, Your Honor, when we did the charge off. The interest that was due at that time was $368.77.
Give me that, please.
$368.77. The total loan balance that we have was $3,519.08. I didn't recall what you said. I apologize.
Well, I got 3,523.98.
That's close, yeah.
Anyway, these are very poor pleadings, even if it is small claims. She's entitled to know what it is that she owes and how it was calculated. But we are in small claims. The rules are more liberal. If this was a general civil case, it'd probably get bounced.
Your Honor, I do apologize. We did send her final letters regarding what the balance was at a couple of different times. So
I haven't been getting my mail.
If she has moved,
I live in a motel room.
All right, same thing, just wait. I don't have to like it. The other fact is they then waited 2 years and they laid this on her desk and hey, said file a small claims action for this. So I don't really like much of it at all, but I don't have to like it. $3,523.98 plus $368.77 in interest is $3,892.75. Close, $3,887.85. Your number is actually lower. This long, I'm sorry. You just think you're getting somewhere. You get a new job, you're at Walmart, you got full-time employment, and blammo, you're paying for a dead horse that you don't own anymore from 2 years ago.
I've been without a car for 2 years. I walked over a mile back and forth to frickin' American Axle.
Well, I wouldn't call it frickin' American Axle. It's probably actually one of our better employers. It's hard work, but it pays well and has decent benefits. Yeah, I don't know what the decision was. They weren't willing to take a partial payment, so they took your car, sold it for half of what you owed on it, sued you for the rest. Doesn't seem fair, does it?
I have no way to pay that right now. I really don't.
Well, that's fine. It's just a judgment that says you owe money. They can attempt to collect. Right now, you're one step away from homeless and you just got a new job. However, this judgment's good for 10 years. I'm going to use their figure, which is lower than the one I calculated. There's also court costs of $86.25 filing fee and $68.19 service fee, for a total of $4,042.29. And right now you're in room 128. They're on 131.
Yes, sir.
And that's close to work, so that's good. The problem is it's very expensive. You're probably paying over $1,000 a month for rent.
I pay $360 a week.
Yeah, that's a lot. Let's see what that is.
It's around $1,400 a month.
Yeah, that's a lot for a motel room. I don't know what to say, but right now you're not in a position to make a payment agreement.
I worked at American Axle for 2 years. I just got fired over Christmas.
All right, I'm sorry about that. Were you in the union?
Yeah.
It's hard to fire somebody in the union out there. I'm not sure what happened, but at any rate, I will send you this. You owe this amount of money. If they do try to collect or garnish your wages, you can file what's called a request for installment payments. If you get a garnishment or something, you contact the clerks. But I find by the preponderance of evidence standard necessary in small claims that they met their burden of proof through sworn testimony, barely, that you owe that amount of money. All right. I'll send you a copy of that, and we'll send a copy also to the Venture Credit Union. I guess it was an adventure, but not a very good one. All right, everybody. That completes that portion, and I wish you luck this long.
Thank you.
Okay. Thank you.
Thank you.